law firm of Wicker Smith in Orlando. Your Honor, I would like to reserve 3 minutes for rebuttal, if I may.
Just 3, okay. Go ahead.
I represent all of the petitioners, but I'm going to refer to my client as NCH, just for brevity's purpose. So just so the panel understands, if I'm referring to NCH, I'm referring to Naples Community Hospital as well as the other petitioners in this case. Our petition really addresses 2 distinct views about how the Medical Malpractice Act works. It is our position, or NCH's position, that you cannot amend a complaint to assert a claim of vicarious liability against the hospital for the acts of a physician whose specialty was never the subject of an investigation during the course of the pre-suit period. And it is Mr. Scola's position that once a hospital has been put on notice with an affidavit that corroborates vicarious fault in a specific specialty, then that opens the door to be able to assert a claim of vicarious liability in any specialty, regardless of whether that specialty was the subject of an investigation. So it's just 2 very fundamentally different views of how the Medical Malpractice Act works. In this case, there were expert affidavits as part of pre-suit in the fields of infectious disease and internal medicine. And almost 3 years after the events that gave rise to the lawsuit, so after the statute of limitations had expired, Mr. Scola filed a motion for leave to amend the complaint to assert a claim of vicarious liability against NCH for the acts of Dr. Ford, who was a radiologist. There was never—
Counsel, hasn't this whole scenario been more or less played out in the Mirage case, the 4th District case?
Yes, Your Honor. And so the position that we are taking here is that Mirage was wrongly decided, and that you would, we would
have to acknowledge conflict with Mirage if we accepted your position.
I believe so.
I've read it several times and I couldn't find much. You couldn't put a sheet of paper between that case and this case as I read it.
I did not address it properly in my reply brief, but in preparing for today's oral argument, I came to the same conclusion. I think that, but I think we should certify a conflict. I think that this is an important issue as to
one other thing that you're battling is that in none of the other cases did we have this scenario where Dr. Ford was identified as a Fabre defendant. In other words, the hospital or NCHMD, I'm not sure if it's a hospital or what kind of a clinic it is, but they pointed to him and said, hey, he's the reason he ended up in this mess to begin with was because NCHMD pointed to him as a Fabre defendant.
I don't believe that naming Dr. Ford as a Fabre defendant excuses the Mr. Scola from having to comply with the requirements of the Medical Malpractice Act. And
well, it certainly feeds the argument that there was notice and awareness of his role.
And actually, Mr. Lugar, let me follow up with what Judge Black was asking. Isn't the whole purpose of the Medical Malpractice Act, the pre-suit requirement, is to put people on notice of whatever theory is so they could investigate it, they could resolve it, they could agree to that. So in this case, if you look at the facts as presented, the affidavit that was submitted, doesn't it show that your client, that NCH, was clearly placed on notice that it's, and I'm looking here, their agents or apparent agents would be held responsible under theory of vicarious liability? Doesn't that provide notice for them?
there are 2 components to the Medical Malpractice Act. It's notice and corroboration. And the expert affidavit has to do with corroboration. And I think that the trial court, I think that's the departure from the essential requirements of the law by the trial court, because they conflated the 2, okay? We had notice of the existence of a claim, but it is our position that you can't put in a notice of intent that we are going to hold you vicariously liable for all of your agents, apparent agents, employees, et cetera, and allow that to sort of open the floodgates to any potential amendment down the line after the statute of limitations has expired. So but
if I may, but if you look at the affidavit here that was presented, didn't they go through and basically said they named some of the defendants, some of the physicians by name, but then indicated the hospital through their age and apparent age for their and here's the key, for their failure to diagnose and treat Mr. Scola's epidural abscess. So there was corroboration by virtue of an affidavit also submitted this. So you have not only notice, you also have a corroboration. And I guess which leads me to my question, which is concerning, to follow your point of view, that means sometimes Fabry defendants are not brought up until much, much later on. Wouldn't that be a catch-22 that somehow you have to anticipate a Fabry defendant? You have to be able to do that from the get-go. Isn't that their concern if we follow that lightning?
I disagree with the initial premise, Your Honor. So the affidavit doesn't corroborate a claim against a radiologist because by definition, statutory definition, an infectious disease doctor cannot render that opinion, cannot corroborate a claim against a radiologist.
But as I understand, but if I may, I understand here, they're not seeking an action against the radio. They're just going against the vicarious liability of the hospital, aren't they?
Yes, they are, Your Honor, absolutely. And that is a distinction that Mr. Scola has repeatedly argued, both at the trial court level and on appeal. And it's our position that you can't do that. You can't have an investigation conducted during pre-suit by an infectious disease physician, an internal medicine physician, and then turn around 3 years after the cause of action accrues and sue a hospital for its vicarious liability for the acts of a radiologist. And again, this is where we disagree, and that's the crux of our petition, is that you should not be allowed to do that. And it's Mr. Scola's position that of course we can. All we're doing is honing our arguments, and so that's our fundamental disagreement. And obviously the burden's on me to show a departure from the essential requirements of law. But I think that the argument that we have raised is that an infectious disease physician and an internal medicine physician cannot, as a matter of law, render an opinion that corroborates a claim against a radiologist.
The vicarious liability allegations that are found in 4 out of the 5 counts of the amended complaint, they really haven't changed. The only thing that changed was the doctor's name was added to the pleading.
Well, no, Your Honor, a specialty was added. That's the key, okay? It's not just an individual
All right,
doctor.
His name and his specialty.
Well, that's a key difference. That is everything. That is the key to our argument, is that you can't bring in or amend your complaint to assert a claim of vicarious liability against a hospital based upon its vicarious liability for a specialty that was never the subject of the pre-suit investigation. And Mr. Scola certainly had all the information. He had all the medical records. And so it's not a catch-22. It's not a gotcha tactic, because they had all the medical records. All they had, all they had to do was retain a radiologist and we wouldn't be here, but they didn't do that. But it's not a catch-22 because there's no allegation that we withheld medical records or we withheld the identity of Dr. Ford, as some of the case law that is relied upon by Mr. Scola. There's one example where the defendant actually withheld information with regard to the name of the doctor who performed the work that was the subject of the pre-suit investigation. And so instead of identifying the specific doctor, the notice of intent generally or specifically described exactly what that doctor did, even though they didn't name him by name. And the district court said, that's fine. You've complied with the statute when you do it that way. This case is different, okay? This case is very different because there was never a radiology review. And so the plaintiff should not be allowed to amend their complaint after the statute's run to assert a claim of vicarious liability against the hospital for the acts of an individual physician who practices in a field that was never the subject of a pre-suit investigation. And we're not obstructing Mr. Scola's access to courts. That issue has been dealt with repeatedly, where getting a proper expert review is not a denial of access to courts, and Mr. Scola is in court. Mr. Scola properly executed the pre-suit investigation with regard to infectious disease and internal medicine, and that's what this case should be tried on, not on the NCH's vicarious liability for a radiologist. I've cited two.
There were 2 more cases that the judge cited, which I believe we would be in conflict with if we decide as you're requesting, which was Columbia JFK Medical Center and the Davis case. You agree that we would have to
No,
that we would be in conflict with those cases as
No,
well?
Your Honor, those are fundamentally, factually different. Davis involved a claim where the notice of intent dealt with the actual intraoperative procedure. And then when the suit came, it alleged negligence in the post-surgical treatment and care. That is a classic example of just honing what facts you're trying to prove. That is not going into an entirely different specialty. That's the key. That's what makes this case different than the cases that the trial court relied upon, is that what Mr. Scola is attempting to do here is amending their pleading to assert a claim against a different specialty. And I keep on repeating myself, but I feel like that's the crux of this petition. And so all of the cases that were cited in Mr. Scola's answer brief, going back to the trial court's order of what was cited, those cases are factually different, and so therefore you would not have to certify a conflict with Davis or JFK or Columbia JFK. But I do concede
So
that
only the Mirage case.
Yeah, I do concede that point, that if this court were to rule, were to agree with my argument and grant the petition, that it would be appropriate for the court to certify a conflict with Mirage.
Okay, thank you very much.
The 766.104 sub 1 states that an investigation means that the attorney has reviewed the case against each and every potential defendant, has consulted with a medical expert, and has obtained a written opinion from said expert. But under the definition of an expert, the cases, the appellate decisions are many, in which there's a requirement, especially since the statute was amended roughly 10 years ago, where same specialty means just that, same specialty. And so that precludes an infectious disease physician or an internal medicine physician from rendering an opinion that is critical of a radiologist, because those specialties are fundamentally different. And so I would ask that the court, relying on its prior decisions in Rell and Bonatti, which adopted the 3rd District's analysis in Largy, to grant the petition on the basis that the amendment in this case is improper, and therefore Mr. Scola's case should go to trial based strictly on the specialties that were the subject of the pre-suit investigation. And unless the court has any further questions, I would like to reserve the remainder of my time for rebuttal.
You can have up to 5, and so.
How am I doing? I don't have a clock.
Okay, all right, so when you come back, you'll have 5, okay.
Great, thank you.
Ms. Rockenbach?
Good morning, may it please the court. It's my pleasure to represent Mr. and Mrs. Scola. The Florida Supreme Court and the legislature have made it clear that the pre-suit requirement exists, the statutory requirement exists to reduce frivolous lawsuits, or it requires the early determination of meritorious claims. In this case, there is no contention that the claim against NCH for its negligent radiologist, Dr. Ford, isn't meritorious because the defendant, Naples Community Hospital, after conducting their own pre-suit investigation pursuant to the statute, they concluded that Dr. Ford's conduct fell below the standard of care. We know that because they're the ones who listed him as a Fabry defendant and disclosed an expert to blame Dr. Ford. And that's why we're here. We're not here because of some failure to comply with a pre-suit notice. My clients absolutely complied. And Judge Kizom, you did note the catch-22 that the Scolas find themselves in. That's exactly what the Florida Supreme Court said that this statute is not to be used as. In Kukral versus Macross, the Florida Supreme Court said this statute must be liberally interpreted and liberally construed so as not to restrict my client's constitutional guaranteed access to the courts. And at the same time, the statute screens out frivolous claims. Well, we know right here that counsel and I agree. NCH has finger pointed to Dr. Ford. They have an expert saying that Dr. Ford fell below the standard of care. The defendant, NCH, cannot use that statute as a sword against the plaintiffs. The Florida Supreme Court said that. So this is not about a technicality. It's not about parsing the notice statute. The affidavit, and I wanted to address this issue because it's not about the infectious disease affidavit. It's about Dr. Raymond Shasheti. He was the internal medicine and hospital medicine expert. He's not just internal medicine. He opined about the hospital's negligence. And Judge Kuzum, you noted it correctly, and we wrote about it both in our pre-suit notice and in the affidavit. The affidavit itself talks about he's familiar with hospital medicine, prevailing standards of care, and it's my opinion that the claim of negligent injury against the following providers, he names NCH, and then he says, by and through its agents, apparent agents, servants, or employees, including but not limited to. And that's where we go to the case law. The other DCAs have interpreted this language. And Davis from the 5th DCA said the statute doesn't require corroborating experts to identify every possible instance of negligence. They've also said, I think it's the 5th DCA talks about, I'm sorry, Columbia, the 4th District Court of Appeal, Columbia JFK versus Brown says there is no need to list every possible instance of negligence, and the affidavit does not need to be defendant specific. So the question is, did we put them on notice? NCH agrees. And then the question is, did we have the corroborating evidence? And the Scolas absolutely did have the corroborating evidence. They sufficiently demonstrated that they performed a reasonable investigation into the claim. And that is borne out in the affidavits, the corroborating affidavits, and specifically Dr. Shasheti's affidavit. The court's faced in this unusual scenario in which, but for NCH's Fabre affirmative defense, and then its listing of an expert who will opine that Dr. Ford is negligent, we would not be here. And my clients would not have sought leave to amend.
I was
But
going to ask you that very question. If you take the Fabre issue out of this, would you still feel as though this complaint could stand because of the vicarious liability language, even though Dr. Ford hadn't previously been pre-suited?
I didn't, I
In other
do.
words, if you just
I
take
do,
the
yes.
Fabre out of the
Right.
equation, where
The-
NCHD pointed to him and said, here's the guy, this is the person that is at fault.
Yes.
If we didn't have that and we didn't have an expert pointing at him would you advocate for the same result?
I
In other
would.
words,
Mhm.
go ahead.
I would, because of the Dr. Shasheti affidavit that talks about hospital medicine and discusses agents and apparent agents, and that Dr. Ford, and that's our position, he's a radiologist. My client did not ask for him. My client was visiting the hospital, I think a course of 7 days. He walked in, he was ambulatory, and by the end of 7 days, he is a quadriplegic. And so Dr. Ford misread the 2018, the April 18, 2018 MRI. And one of the allegations in the affidavit and the notice of intent discussed the infectious disease doctor's negligence, Dr. Brown, and said Dr. Brown did not go back and talk to Dr. Ford about the MRI. So NCH absolutely was on notice. And then this affidavit does support and does provide the appropriate corroborating evidence. But it's really important for the court to look at the purpose of the statute. The purpose of this statute is to weed out frivolous claims and weed out frivolous medical malpractice lawsuits. NCH cannot stand before this court and say that any claim or finger pointing to Dr. Ford or NCH on behalf of Dr. Ford is frivolous, because NCH itself is pointing to Dr. Ford. The factual question of relationship is one for the jury to decide. And the verdict form would absolutely say, because NCH has listed Dr. Ford as an affirmative, a Fabre defendant in their affirmative defense, the verdict form would ask, was Dr. Ford acting in agency with or as an apparent agent of NCH or individually? And so if the jury finds individually, then they win on their Fabre defense. if the jury finds agency, which we have pled by our amended complaint, then we win that aspect. But the NCH can't have its cake and eat it too. They want to point to one of its own. It's radiologists. This is an in-house a parent agent or agent of the hospital, and say, this is the negligent bad actor. But plaintiffs, you may not point to him. And that is not, that's really, it's misleading to the jury, and it does not comport with the intent and the purpose of the statute, of the pre-suit statute. So the question that if the defendant determines that there is an additional bad actor, can the plaintiff then seek to amend against that hospital defendant who was satisfactorily given pre-suit notice of its liability for its agents? The answer to that question has to be yes. We stayed in our lane. The plaintiffs did not go out and sue Dr. Ford individually. We amended as to the hospital. We simply adopted the hospital's finger pointing or blaming of Dr. Ford. We do, and I think Judge Black, you identified the Mirage case. That really does apply to the relation back. And so I really didn't see too much of that argument in the petition for writ of certiorari. It was raised below about whether it could relate back, but under Rule 1.190, our amended pleading absolutely relates back to the original pleading because it's the same conduct, same transaction, same occurrence. Even if it does raise a new legal theory, that's appropriate. So this court should follow the Mirage decision from the 4th District Court of Appeal, but also instructive for this court are the Michael case and the Columbia case out of the 3rd and the 4th District Court of Appeal, because the Florida legislature did not require my clients to specify each and every potential vicarious liability defendant. They didn't do that. The rule of civil procedure that governs the pre-suit notice likewise does not require that. So consistent with the Florida Supreme Court's dictate and an interpretation of the legislature's enactment of this statute, my clients absolutely complied with both the notice and the corroboration prongs of the statute. And the Kukral versus Mecros Florida Supreme Court decision guides this court to disallow NCH from using the statute as both a sword and a shield. My clients deserve to amend the complaint as the trial judge appropriately allowed them to do, because the corroboration through the hospital medicine expert, Dr. Shashady, absolutely gave rise to the hospital to investigate on their own, which is part of their pre-suit obligation under 766.203. They have a pre-suit investigation that occurs within 90 days after we give them notice. And we even named Dr. Ford in our notice. And so there's absolutely no reason why my client should not be allowed to join the hospital in blaming Dr. Ford. And so we ask that you affirm the trial court's decision to deny the motion to dismiss. There has been established no departure from the essential requirements of law. And so there should be no issuance of a writ of certiorari. If there are any questions from the court.
Thank you very much, Ms.
Thank you.
Rockenbach.
Thank you.
Mr. DeLugo, you've got 5 minutes, sir.
Thank you, Your Honor. I don't believe I'll need 5, but thank you. So Mr. Scola's counsel raises an interesting point in that the purpose, the statutory purpose behind the medical malpractice pre-suit is actually twofold. Okay, it's not just one purpose. It's not just to weed out, to make sure that the claim has merit. Obviously, I can't sit here before you and claim that it doesn't have merit if we're going to name him as a Fabre defendant. But the second purpose is to facilitate the potential early resolution of the claim. And NCH was deprived of that aspect of it when Mr. Scola's investigation was focused on 2 specialties that NCH felt were not not a problem in this case, that the problem was radiology, but that Mr. Scola didn't go there, even though they had the medical records. It's not a catch-22. They had the medical records. They had the ability to figure out what went wrong. And They just didn't, they chose to go in a different direction. And we don't feel that the manner in which we plead our defenses is, impacts the requirements under Florida law to conduct a proper investigation. And then the second point that I want to raise is that we are not, and we have never taken the position, because the case law very strongly indicates otherwise, we have not taken the position that it is a requirement under Florida law that the notice of intent identify every single instance of medical negligence. That's not what the case law interpreting the Medical Malpractice Act stands for. All the districts are in agreement. I'm not trying to confront that law. That's not the position that we're taking. We're merely stating that the requirements of the Florida Medical Malpractice Act dictate that the investigation that is conducted must be in the same specialty as the person against whom you are raising a claim. And that is true whether it's a vicarious claim or a direct liability claim. The plaintiff in this case should not have been allowed to amend their complaint to assert a claim of vicarious responsibility against NCH for the acts of radiology, a specialty that was never the subject of an investigation during pre-suit. Thank you very much for your time. I appreciate it, and have a good day.
Thank you both. You both did a great job today, and we appreciate it very much. Have a good day.
Thank you.
Thank you, Your Honor.
Our next case is Gloria Priest versus Wells Fargo.